All right, good morning, everyone. It's March 7th, 2024, and this is the meeting of the Law and Policy Committee of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Chair Matich?
Here. Go ahead and proceed with item 1, public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll
Yes,
proceed.
please.
Oh, go ahead.
Hello?
Hello.
I'm sorry. I didn't know if there was a way to raise a hand or not. I do have a comment, please.
All right, good. This is public comment for things not on today's agenda.
This
Correct.
is Steve Petzold in Santa Clarita, California.
Good morning, Mr. Petzold.
Well, good morning. I was so excited to see the agenda alert this morning. So my concern this morning is whether Citizens Bond Oversight Committee should be made subject to the Conflict of Interest Code. I found several situations here in Southern California where it's unclear. Many local agencies, specifically community colleges, seem to have differences on whether the members should be subject to the Conflict of Interest Code. So within your legislative abilities there, I certainly think that it would be within your realm to suggest legislation to make Citizens Bond Oversight Committees subject to the Conflict of Interest Code and have them file a Form 700. I have put forward a written public comment from the CEO's office of Los Angeles County that explains what the criterion is for having them reporting. And since a Citizens Bond Oversight Committee is required annually to report whether the local agency is in compliance with the California Constitution, I believe that that in and of itself should make it subject to the Conflict of Interest Code. Down here in Santa Monica College, for instance, their members are subject to the Conflict of Interest Code. But my friends at College of the Canyons in Santa Clarita, their bylaws say that they are specifically exempt from the Conflict of Interest Code. And I found several instances where I think it would be important for the public to have that information. So with those wise words, I will listen for any comment that you may have. But we have to have somebody up there at FPPC take a look at this issue and require all Citizens Bond Oversight Committees. I believe the Education Code clearly states that the functions of the Citizens Bond Oversight Committee would put them in within the guidelines for filing Form 700. And I will sign off with those words to you and wish you all a good day.
All right, thank you, Mr. Petzold.
Don't forget to change it's time change, so spring forward on Sunday, okay?
Yes, an important reminder. Thank you again, Mr. Petzold. Mr. Bainbridge,
bet.
can I put you on the spot? Do you happen to know off the top of your head, have we ever addressed this issue?
I don't know.
All right. Commissioner Baker, I think this is something that perhaps Mr. Bainbridge could take a look at and report back to the commission at a future meeting on whether or not there is an issue here for us to consider addressing legislatively.
I would agree. Appreciate the issue being raised with us and what local committees, part of that would be what local committees have we previously had any involvement in and what jurisdiction, how much we've deferred to local jurisdictions to determine that for themselves. So I would appreciate that update as well and leave to Mr. Bainbridge or the chair of the time frame for doing that.
Can I ask Mr. Petzold, sounds like he's still there, what the board, what this, it's a bond oversight for community colleges, what's the entity? So I know exactly what we're looking at.
Well, for all Prop 39 bonds, those are bonds that are issued subject to Proposition 39, year 2000. A Citizens Bond Oversight Committee is required. So under Prop 39, it circumvents Prop 13 by allowing a bond to be passed with a 55% supermajority rather than a 66% supermajority. And the Education Code defines broadly what the functions of the Citizens Bond Oversight Committee are. But over time, many institutions, local agencies, this applies not only to community colleges, but also secondary, high school districts and what do you call them? General education, 1 through 6, any of those that go for the 55% supermajority have to establish a citizen bond oversight committee. And they have to report back that the local agency is in compliance with Proposition 39, the Constitution.
Okay, so not
In many
specific to
cases-
community colleges then. Got it.
It is not. It's on any Prop 39 bond. It could be your grade school, your high school, but, my specialty is community colleges,
Okay, we will look into that.
one in particular. So I don't think there should be a disparity between whether they are subject to it or not. That ambiguity should be answered clearly.
Thanks, Mr. Petzold. Commissioner Baker?
Yes, I would just add, it sounds like he's mentioning community, Prop 39 in an education realm. I am aware that there are citizen oversight committees for other bonds that are not education-related, as well as sales tax measures. If we're going to have our team do the work on this at all, if we just want to look at bond or sales tax, citizen oversight committees, kind of, I don't want to say one and done, but if you're going to go through the effort, it might be better to not be too narrowly focused.
Yeah, no, I think that's actually important, because then we'll understand whether the Prop 39 oversight committees, whether there's parity with other types of oversight committees. So I think you're right. Cast a wide net, Mr. Bainbridge.
Okay.
Thank you. Thank you again, Mr. Petzold. Any other public comment for items not on today's?
Yes, Chair, I do.
Go ahead.
So thank you for the opportunity. I'm a resident of Fremont, and I'm calling with some concerns about the long delay in processing FPPC sworn complaint numbers 2020-00750 filed in September of 2020 and 2022-0808 filed in November of 2022. These complaints were filed 3 and 1.5 years ago, respectively. The respondent to these complaints, Benny Bacon, has previously been found guilty of violations in December of 2017, file number 2016-19928, and he was fined several $1,000s. He was also found guilty in March of 2022 of failing to file a statement of economic interest in complaint number 2022-00121, and he was issued a warning letter regarding that complaint. Besides the long delay, I have many concerns, as do our residents, because Mr. Bacon recently ran for and won a seat on the Alameda County Democratic Central Committee, and he has also announced his campaign for Fremont Mayor for 2024. Constituents deserve to know in a timely manner about the outcome of these complaints in order to make informed decisions. So please prioritize the processing of these complaints. Thank you.
Thank you, sir. Appreciate it. We do have our Chief of Enforcement, Mr. Lindsay, here, and as is customary, perhaps Mr. Lindsay can reach out to you and give you an update on the processing of those cases. So we'll ask him to do that. Are you the
very much.
complainant, sir?
I am not.
Okay, well then, Mr. Lindsay will reach out to the complainant that we have on file.
Very good, thank you.
Thank you. Any other public comment for items not on today's agenda? Hearing and seeing none, we'll proceed to item 2, approval of the January 2024 committee minutes. Commissioner Baker, any edits, comments?
No, thank you. Move to approve.
I will second. Any public comment on item 2? Hearing and seeing none, Ms. Linker.
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, thank you. We'll now proceed to item 3, our legislative update with our senior FPPC Legislative Counsel, Ms. Nakano. Good morning.
Good morning, Chair Matich, Commissioner Baker. Nice to see you both. So the legislature is in full swing. There are 19 commission-related bills that are active right now, including 7 spot bills. The spot bill deadline is March 11th in the Assembly and March 20th in the Senate. So I will likely have more to report on those bills at the commission meeting later this month. Before I jump into the bills, I'll note that there were committee membership changes due to the recent leadership change in the Senate, and those are noted in the report. For updates, I'll start with the commission-initiated bills. AB 1170 by Assemblymember Valencia, a two-year bill relating to electronic filing of statements of economic interests, passed in the Assembly 77-0. We're continuing to engage stakeholders on the bill to ensure that if the bill passes, implementation goes smoothly. AB 2001 was introduced by Assemblymember Gallagher. The bill includes several of the Commission's minor and cleanup change proposals. The bill was referred to the Assembly Elections Committee, but the hearing date has not yet been set on that one. AB 2631 was introduced by Assemblymember Mike Fong. The bill would make the FPPC's online local agency ethics training program a permanent program in statute. That bill was also referred to the Assembly Elections Committee and was just set for hearing on March 20th. AB 3008 was introduced by Assembly Members Ramos and Garcia. The bill would amend the government income exception for purposes of the conflict of interest provisions in the PRA to include an exemption for salary and reimbursement for expenses or per diem, Social Security, disability, or other similar benefit payments received from a tribal government agency. I'll note for the committee that the parameters of the bill are still in discussion. When the Commission discussed the proposal previously, the contemplated proposal would have included only salary and benefits from a tribal government employer to a tribal government employee. The author has expressed interest that the exception would also cover other benefit payments to tribal members. I'll also mention that FPPC staff and members of this committee will be meeting with the author's office and tribal representatives later today to get more background on the bill. And I'll report back to the commission meeting about those discussions. SB 1027 was introduced by Senator Menjivar. The bill would require the Secretary of State to redact the bank account number and the names of persons authorized to obtain bank account records from a committee's statement of organization before providing that statement to the public. The bill would also authorize a committee to omit that same information from the copy of the statement that's filed with the local filing officer. I'll note that due to limitations within the CalAccess reporting system, the portion of the bill requiring redaction of the names of persons authorized to obtain bank account records would become effective only after the CalAccess replacement system is online. SB 1027 was double referred to the Senate Elections Committee and the Senate Judiciary Committee. It is set for hearing in the Elections Committee on March 19th. SB 1404 was introduced by Senator Glazer. With one notable addition, the bill is the same from last year's bill, SB 569. This would transfer the lobbying audit duty from the Franchise Tax Board to the Fair Political Practices Commission. This year's bill would also impose an additional annual fee on lobbyists. The fee would be deposited in a new fund, which would be continuously appropriated to the commission for purposes of administering the new lobbying audit program. The amount of the fee would be set by the commission in an amount to offset the costs of the program. That bill was referred to the Senate Elections Committee. I'll pause here for any questions or comments on commission-initiated bills.
Commissioner Baker, any questions?
I have none. Thank you. Your memo is very thorough.
All right. I just have one ex parte disclosure. Ms. Nakano, you and I did meet with Assemblymember Ramos and his staff on AB 3008 previously. So consistent with our disclosure requirements, I wanted to disclose that contact. I have no other questions, though.
Thank you. All right, I'll move on to other commission-related bills. AB 2041 was introduced by Assemblymember Bonta. This bill is a reintroduction of last year's bill, which would have expanded the permitted use of campaign funds for security expenses. The bill includes some differences. Specifically, the bill provides that it does not authorize campaign funds to be used to purchase firearms, and the bill extends the return or reimbursement requirements to all tangible security-related items purchased with campaign funds, not just security systems. The bill was referred to the Senate Elections Committee. AB 2803 was introduced by Assemblymember Valencia relating to the use of campaign funds for legal defense costs. For background, the PRA permits campaign funds to be used for legal defense costs if the litigation is directly related to a political, legislative, or governmental purpose. The bill would further limit the permitted use of campaign funds for legal costs by prohibiting expenditure for attorney's fees, other legal defense costs, or any fine, penalty, judgment, or settlement relating to a conviction for a felony or an offense that involves moral turpitude, dishonesty, or fraud. Staff are in conversations with the author's office to seek some clarifications on the bill, including on the definition of moral turpitude, dishonesty, or fraud. That bill was also referred to the Senate Elections Committee. SB 1151, introduced by Senator Hurtado, would make the agent of a foreign principal subject to the same registration and reporting requirements as lobbyists and lobbying firms under the PRA, with an additional requirement to report on their registration statement any compensation received or promised to the agent by each foreign principal. The bill would also prohibit a foreign agent from being a commissioner with the FPPC in the same way that active lobbyists may not serve as commissioners. According to internal analysis of the bill by Senior Commission Counsel Kevin Cornwall, many of these individuals may already qualify as lobbyists and would already be required to register and submit reports. However, the bill does not have the income and compensated time thresholds as applied to lobbyists, so it may capture more individuals in that way. And that bill was also referred to the Senate Elections Committee. SB 1155 was also introduced by Senator Hurtado. The bill would prohibit the head of a state administrative agency from lobbying the legislature or any state administrative agency for compensation for 1 year after leaving state service. Because the bill would extend the prohibition to appearing before any agency, not just the official's prior agency or the legislature, it is broader than the existing 1-year ban that prohibits certain officials from appearing before their own agency under certain circumstances. The bill was referred to the Senate Elections Committee. One more bill from Senator Hurtado, SB 1156 would amend the Water Code to create separate financial disclosure reporting requirements for public officials with groundwater sustainability agencies. These requirements would be administered and enforced by the FPPC. After consulting with the legal division, we've determined that these agencies are already subject to the Political Reform Act, including the requirements to adopt a conflict of interest code and submit statements of economic interests. So we're in conversation with the author's office to clarify their intent, provide feedback on the bill, and possibly suggest amendments. I'll keep the commission informed as that progresses. The bill was double referred to the Senate Natural Resources Committee and was set for hearing on April 9th and to the Senate Elections Committee. SB 1170 was introduced by Senator Menjivar. The bill would permit campaign funds to be used for mental health care expenses for a non-incumbent candidate if the candidate does not have health insurance or has been denied coverage for these mental health care expenses by their health insurance. Expenditure for these purposes would be permitted starting the date the committee is established and ending when the election results are certified. Under existing law, campaign funds generally cannot be used for any health care expenses. The bill is sponsored by California Women's List, a general purpose committee that endorses, fundraises for, and elects women to public office in California. The bill originated from a report published by that group on analyzing the mental health impacts of hostility that women face pursuing political office in California. The report includes, among other information, survey results from candidates who ran between 2016 and 2022 and policy recommendations. The report includes extensive statistics, including that 65% of women and 50% of men who participated in the study experienced harassment during the campaign, and 80% of all respondents reported experiencing new mental health or wellness-related symptoms that they believed were caused, in whole or in part, by hostility that they experienced during their campaigns. We're in conversation with the author's office and the sponsor regarding the bill. They're open to and interested in feedback from the commission. SB 1476 was introduced by Senator Blake Spear. The bill would clarify that the State Bar of California is required to adopt a conflict of interest code, and its designated employees are required to submit statements of economic interests. The California State Bar initiated this proposal. Staff are working with the author's office and the sponsor to further clarify exactly which provisions of the PRA the State Bar would be subject to under the bill, and we may provide feedback to assist in effectuating that intent. This bill was double referred to the Senate Elections Committee and the Senate Judiciary Committee. The remaining bills are spot bills, and I'll update the commission if and when they are amended. But that concludes my update. Happy to take any questions.
I have a couple questions for you. First, I think I've anecdotally heard that there may be some interest in a bill related to Form 807s and tightening up the requirement for reporting by entities that pay for legislator travel. Do you have any updates on that?
a stakeholder reached out to us on that bill. I don't know for sure that they have secured an author. I think those talks are still happening, but if I have any confirmation that something like that's going to happen, I'll let the commission know, and I'll try to find out more detail.
Okay, thank you. Secondly, I want to go back to the Valencia bill. This is use of campaign funds for legal defense. It's AB 2803. You mentioned that we were, because internally I know we've had some conversations about, well, what are crimes of moral turpitude, dishonesty, fraud? I think that's important that we have clear definitions if we're going to do this in this bill. So I appreciate staff doing that. Also, I think there was a question of whether this would apply to all felonies or just those that involve moral turpitude, dishonesty, or fraud. So I appreciate that staff's already approaching that. Do you know today whether or not the intention of this bill would be to allow the use of campaign funds and a legal defense fund at the outset of charges? So charges are filed against a candidate or an elected official. They include at least one that we can stipulate for this conversation would be a crime of moral turpitude, fraud, dishonesty, et cetera. But there are many charges, not all of which fall within that category. Is it your understanding today that that candidate or office holder could open up a legal defense fund and use campaign funds raised into that account for purposes of their defense at the outset?
And that this is particularly a circumstance where they have multiple charges and only some of them relate to moral turpitude, fraud. I think broadly, the bill would allow them to initially expend those funds, and if they are convicted, that they would have to reimburse. If it's multiple charges and not all of them are covered by this bill, the intent is that, or the hoped-for intent is that they'll be able to get the bill to a place where they can allow the candidate or officer to use funds for those other charges and not be able to use funds just for those certain felonies and offenses. However, they're aware that accounting-wise, this might not be possible, the way that legal fees are billed and accounted for. So that's still kind of in discussion about whether that's possible to effectuate in the bill or whether it just won't be practical.
Okay, so, but the basic premise is you can set it up, you can raise money into it, and it's only upon litigation results in a conviction that triggers a potential repayment obligation. Is that correct?
That is
how I
the language of
understand
the bill. They do refer specifically to convictions
it? Okay,
as the trigger.
okay, so unless you're convicted, you don't have to pay the money back. Is that correct?
Right.
What if you settle?
That's a good question. I think it's ambiguous in the bill because the bill language does mention settlements.
Right.
However, the trigger is convictions. So I think that's an area where, again, we need some further clarification.
Okay. I think that's important to understand from the author's perspective what their intention is and their goal is so that we can administer this properly. I also, and you've already touched on this, it seems to me that ultimately in the case of mixed charges, some of which would be prohibited from using these funds, others would not, that the record keeping is, I would anticipate being difficult because you're talking about attorney-client privilege potentially. So I don't know if looking at, like 1021.5, other private attorney general statutes where you have to go in and prove up the time that you have spent in order to get a fee award would be useful here for the author, but I might recommend that somebody take a look at least at that to figure out how we do this without violating attorney-client. And then my final point is a broader one, audits of legal defense funds. Particularly here, when we're talking about something that I would anticipate is going to have to require a lot of records, a lot of trust, if you will. They're spending the money on the front end, and then maybe they pay it back on the back end, depending on the outcome. What currently is the law with respect to auditing legal defense funds? How are they selected for audit?
I think when the candidate is audited, their legal defense fund is also audited. It's part of their whole, part of that process. But if there's any additional information that anyone would like to provide at this point, I can.
That's my understanding too, but
Yeah.
Mr. Bainbridge, this would be a good time to tell us we're all wrong.
Yeah, I think it would be, we'd want to ask an auditor. My understanding is when they look at a particular candidate, they look at all of their committees. There's nothing in the law specifically requiring audits of legal defense funds.
Yeah, so the only time we audit a legal defense fund is when they happen to have been randomly selected and a candidate happens to have a legal defense fund. And there aren't very many legal defense funds. I think there's only one or two, maybe, based on the last report I read in the legislature. I wonder if this is an area where we want to require audits on a regular basis of legal defense funds, regardless of whether or not the candidate has had all of their accounts pulled for auditing.
Yeah, but, and even look into if it's a separate draw than the district numbers. That if you do a draw separately to legal, I'm throwing out different ideas. If it's not to change how you get them, I'm learning right now that if you're not pulled in the draw, your legal defense fund isn't going to be audited. So I think that's an excellent point, which means there might be very few of them, but we're going to want to know. While we're on the audit subject, I may just add, I would be interested in hearing from our audit team or Ms. Nakano visiting with them what other questions they might have with respect to how this would be audited. With whatever experience we have in auditing a legal defense fund over the many years, maybe there's been some lessons that we could share with the author, both with this committee and the full commission and the author, so that we can have that education in mind while the bill is being worked on instead of after the fact. So both those are my two audit points.
Yeah, no, I think that's right. And I should probably go back. I appreciate the authors highlighting this issue and bringing this forward as a legislative proposal. I think as a matter of policy, I think it seems to this commissioner to be a good idea not to allow funds to be used for these types of convictions. My concern is more in the details and the implementation, so that it's a practical implementation and effective implementation from our standpoint at the commission. The other bill I wanted to spend a few minutes just asking some questions about is SB 1170, use of campaign funds for mental health expenses. And maybe we can start with a point that you made, which is that the act currently specifically says you cannot use campaign funds for these types of expenses. Do you know, why is it that the act would specifically point to these types of expenses as things you cannot use campaign funds for?
I think generally they have historically been thought of as personal use, medical expenses. I did look a bit into the legislative history, and these provisions were originally transferred over from the Elections Code, so legislative intent was a bit hard to find, but generally speaking, I think it is because they've been considered personal use.
Okay, so historically, that's how they've been considered. Now, I imagine historically, so is childcare, and we recently created an exemption for that. So I'm not saying that history has to necessarily guide us. I think it's important to understand, though, why this is not permitted today, though. Second question, if I understand this correctly, only non-incumbent candidates could use campaign funds for this purpose. Why not elected officials?
That's a good question. I did talk to the author's office about that, and there are a couple of reasons. One of them is that they wanted to keep the bill as narrow as possible. They saw, I think, lessons from the security expenses bill last year, and what they took from that was that they wanted to make it as narrow as possible. And the second reason is that they expect that folks who are already in office would have health insurance that would cover these kinds of costs. So I think their aim is to get at the people who are most likely not to have coverage and not otherwise able to get these services.
Do we have any data? I mean, I know, you can tell me if we're wrong about this, but I know state legislators certainly have access to health insurance through the state. But what about all these locals? I mean, most public officials in the state who are elected at the local level. Is that true, that they all get employer-sponsored health plans at the local level?
Yeah, that's a good question. I can bring that to the author's office.
From my little familiar with it, no, it really completely depends. I know in my area, there's a water board that has full health care, like a very great health care plan and per diem, and that's it. I think BART board, for example, you may, if you're a board director, you may get health care. At local city governments, I'm unaware of any in my area, which is just a small area, but having interacted with several jurisdictions, I don't know of any local governments when you're elected to a city council, for example, that happens. So there's water boards, there's school boards, there's all kinds of elected entities. The legislature, yes, you can have healthcare, but the assumption that once you're elected, you're going to get healthcare is difficult to see. Better to have data, but that's my anecdotal. Yeah. And I will say, the folks who, that's one of the main selling points for being on that water board, is that you and your family get a very generous health plan. I'm not saying the folks who serve on that one, and I'm intentionally leaving it unnamed, are not fully in the heart of it, but that is a known point for that particular one.
Right, I appreciate that background. Another question I have is, would this apply to a pre-existing condition? Like, let's say 20 years ago, somebody was diagnosed with some type of mental health issue, and 10 years later, they choose to run for office. Could they go and receive mental health care and use campaign funds to pay for that condition which pre-existed their candidacy under this bill?
It doesn't specifically address pre-existing conditions. However, the language says that it applies to mental health issues that have arisen during the campaign or have been adversely impacted by campaign activities. So I think it can be implied that it would cover a pre-existing condition if, for example, it was exacerbated by something that happened on the campaign trail.
Okay. And that would be true for the candidate under this circumstance, or I should say, the bill would then permit that candidate under those circumstances to use campaign funds they've raised to pay for those mental health services. But an elected official who had a similar experience would not be able to use campaign funds. Is that right?
Right.
Okay. Under the bill, at least this summary, it says that you can use campaign funds to pay for mental health services if coverage has been denied. So when I see that, does that mean if the insurance company says you don't need this for whatever reason, that they could nonetheless still use campaign funds to seek and pay for treatment?
That I'm not sure. I don't know if it applies when they think the service is not warranted or if it's simply not part of their health coverage. But I can clarify that.
Okay. Well, I think that's just, again, it's a question. I mean, I'm not sure. I think the question for us is, what is the author's intent here? Do they intend to allow candidates to use campaign funds, notwithstanding the fact that they've been denied because the insurance company says you don't need this? There's no proof that you need it. That's up to them whether they want to permit that or not. How, if at all, what is our expectation in terms of records? Like, let's say a candidate is running for office and they spend money on mental health services because this bill has become law. And their campaigns are pulled for audit. And so we audit that, we see those expenditures, we ask for the backup. How do we obtain that type of backup in light of medical privacy record requirements currently in law?
So these expenditures would be ported on campaign statements. So I believe it would be subject to our general record-keeping requirements. I would require them to keep detailed accounting of everything that they report. Specifically, I don't know what that would look like in this bill because of those kinds of protections of health-related information. So that's a good question also to bring to the author's office.
Are there any limitations on the types of treatments that you could pay for with campaign funds? I mean, there's a lot of debate currently in the legislature about decriminalizing, under very limited circumstances, psilocybin, right? And using that as a therapeutic treatment based on current research. If this bill becomes law, would a candidate be able to use campaign funds for that type of a service?
So the only limits on what services could be paid for is in the definition of mental health care expenses. Specifically, it says it refers to expenses for services including therapy, psychological or psychiatric counseling services provided in a group or private setting, either virtually or in person by a professional licensed by the California Board of Behavioral Sciences or an associate accruing hours for that. Looking at the definition, it does appear to be limited to services and not necessarily medications. So that's something that I think in the language, it appears to be limited to services, but I can ask the author's office if there's any intent for it to also apply potentially to medications.
Okay. All right, those were my sort of nitpicky questions on the bill. Again, I think the author's intention is righteous. I think we need more access to mental health coverage for everybody, not just candidates or elected officials. Frankly, I think everybody can benefit from that. Whether this bill accomplishes this or not, what their intentions are, I think, we leave for another day. Commissioner Baker.
Thank you. All great questions. And I appreciate that the author asked for feedback. And so I also appreciate the goal of more healthcare, more mental health care. I echo all the questions that the chair has and want to add a few more. Who will decide if we're compliant and how we decide? So how do we audit that? Not only for the privacy concerns, but are we auditing if the insurance companies denied coverage of something? If the person has insurance, but the insurance companies denied it, or if they don't have any insurance at all? If the doctor recommended the mental health care expense, but the insurance said you didn't need it, so how do we decide what is the best one? The doctor says I should have it. If a doctor is required at all. So how would we understand what is a compliant expense is one. The chair already touched upon what are the drugs that can be considered or the treatments. It could be anything from acupuncture is a service, massage, aromatherapy. I'm sure there's lots of things that could be part of that. Or is it just seeing a licensed professional, not a licensed professional? I mean, there's just a whole lot of questions that would need to be asked, not only to see if the person is complying with the allowed expense if this were to pass, but also if this is consistent with what the purpose of the PRA and campaign funds are for. You're holding them in the public trust for a legislative, governmental, or educational, legislative, governmental, political purpose. And so I think that's bigger picture. Also, if, let's see, other limits on what's allowed is going to be important to look at. And then if we find that there's an expense that was undertaken and it's not allowed, how do you go through the recovering the cost of that? The person's going to have to reimburse the committee. They're going to have to claw that back somehow. And just bigger picture for me is, I think there would be potentially under this, if we nailed all this down over the course of this or any other legislative session, the potential for abuse. And not even necessarily bad abuse, but maybe somebody's like, I need this treatment, I'm not able to get it. I'm going to open a committee and run for something and raise money and use the funds for healthcare because I need it. And I don't know how many people would go through that, but there are certainly times when people are grifters. And I don't want to assume that that's where people would be, but what are going to be some of the protections in here from that happening? Those are the ones that come to mind for that bill. Leaving that bill, if I can go back to some of the others. And I'm going to go back to Assemblymember Valencia, use of campaign funds for legal defense. Chair raised the same question I had is, okay, so what if there are some claims that would count and some claims that don't? How are we going to just practically speaking, how is that going to be both reported appropriately and then tracked? But if there's a plea deal, sounds like conviction only, but then there's appellate. Maybe there's a conviction, but there's going to, a lot of people do an appeal, and that's going to go potentially a long way. So we'd want to know about that. I'm kind of curious about this, and I don't know if the author thought of it. If having access to campaign funds then makes someone not qualify for public defender, that may be broader. I don't know if that's even something that the author would include in here, but I'm curious if by having these funds, they're not able to then access a public defender and get their legal costs covered that way. Full disclosure, when I was in the legislature, I authored a bill that claims related to sexual harassment or sexual assault could not be used, campaign funds could not be used for those. So there's a little bit of legislative history, maybe they've already drawn on. There were other authors who had engaged in that legislation as well. All of those bills were put on hold while the legislature came up with a separate manner in which to determine claims against members and candidates for sexual harassment. But it does raise the question, if you're a candidate or if you are actually a successful official, how that would play out. And if, I mean, I'm not trying to expand this bill to include sexual harassment and assault, but I would think that those are ones that, if you're going to put things in these categories, why not? Why not include those? That's a little bit of my own selfish legislative agenda there, because that bill didn't pass. So-
Can I ask about that?
Sure.
Because I have a recollection early on in my chairmanship, I think it was Senator Leyva had a bill, and I thought that was passed and signed into law on sexual
May have
harassment.
After I was gone,
Yeah,
yeah.
I just,
Yeah.
like,
Okay,
I think, because your point is a good
Yeah.
one, we ought to include that if it's not, but my understanding is that was already included.
and maybe there's some points from that bill and the discussion then that will elucidate how we can make this one better,
Yeah.
potentially.
Yeah. If you could just confirm or deny that it's included, I think that would be
Mm-hmm.
helpful, so we know the scope that we're talking about.
I can confirm. Save Lindsay the trouble. Yes, you're correct, that your recollection is correct. That was added to the law a couple years ago.
Okay, good. My memory
Well, I'm
has
so
not
grateful
totally left
that
me.
I
This is good.
inspired a bill that Senator Leyva then took on. I'm sure that's not how that happened, but, and then I just had some, there, sometimes, I don't know how this works with legal defense fund rules now, but sometimes there are charges that come out of the same facts that are civilly pursued under a different burden of proof, and some are criminally pursued. Obviously, this bill seems to be only focused on criminal. I guess I'm asking the question, does that mean if the person, under all the same facts that would make moral turpitude, fraud, and dishonesty, I don't know if there's moral turpitude claims, it's civil, but if there's a loophole potentially that's being created here for civil. I'm not looking to expand, but those are some questions that I would ask if I were the author or legislative staff. And then I know you're typing away furiously there, so SB 1151 by Senator Hurtado regarding registration and reporting requirements for foreign agents. Very intrigued by this, interesting to me. I'm kind of curious why, if it's never been tried before. Maybe that's more of a legislative history. This seems like something that maybe the legislature has tried over the years. And if it has, I'd be curious what the outcome was. What were some of the pitfalls there that we could be seeing? I'm revisiting here. Post-employment restriction for former heads of state administrative agencies, Senator Hurtado's Bill 1155. I have not pulled up the language. I was just looking at your write-up. I'm curious how broadly, it says certain officials. So what new officials would this be covering? Would it only be for the very narrow, would it be very narrowly defined here, or is there any possibility the language is going to be going broader? I'm also thinking of staff. I feel like we've had bills over the last few years where there were restrictions on staff for potentially getting employment shortly after they leave the legislature, or maybe a city government or a water board. I know this is part of that. I just would want to know what the scope is for that and how much it affects staff, the abilities to move on to different jobs. Those were my questions about the bills. Thank you.
I do have an answer for your last question regarding who it applies to. So they do define head of a state administrative agency. It's defined to include elected state officers and appointed officials at the state level. And I confirmed with them that this would apply not only to an appointed head, like a chair, but also any appointed official with a state administrative agency. Although it says includes, it's not their intent to include anyone other than elected and appointed officials.
And that would assume like commissions like this one?
Yes.
Yeah, okay, thank you.
Any other questions on any of those? All right, Ms. Nakano, it's my understanding we have not been asked to take a position on any of the bills we just discussed. Is that correct? outside of obviously the ones we're sponsoring. I'm talking about the new ones.
No one has requested a position yet. I'm sure any of them would be happy to have our support, but none have requested our position.
All right, just for purposes of planning for everybody, what is the timeline where we would expect those requests, if any, to come in?
The first hearings will start middle of this month, and they'll go into next month. Often the commission prefers to wait until after the first hearing has occurred. We can see what the amendments look like, what stakeholders are saying, things like that. So by April or May, I think, is when we typically take positions.
Okay, all right, so for planning purposes, I think that's important.
Yeah, it would be good to have that happen. Of course, you've got your policy committee deadlines and the fiscal ones, but to have some more hearing, have these, have an opportunity for I call it the outside world to also spot issues that we haven't spotted and maybe get some answers in negotiations. Certainly, it's too early now, but that does help with the timeline. Thank you.
Right, great. Anything else, Ms. Nakano, that you wanted to bring to our attention?
Nothing more from me.
All right, anything further from Ms. Nakano?
No, thank you. Great update on many bills. There's a lot going on over there.
Yes. Any public comment on item 3, our legislative update? Hearing and seeing none, brings us to our final item. Commissioner Baker, any discussion items beyond our legislative update for the April 2024 meeting?
I was going to invite you to see if you wanted to say anything more. You had asked about the travel requirement, and if this is something that is legislative or regulatory that you might be raising. I guess I'm inviting the chair to say more, but for what we might anticipate in the coming months.
Yeah, so after the Cal Matters article came out, staff was made aware of those issues. Staff began some internal work to evaluate whether the fact that few, if anybody, had filed these reports was a consequence of us not enforcing it, if it was a consequence of how the statute was written, an absence of regulations, or some combination of the three. Staff has provided some initial feedback, which I think suggests at a minimum the statute could be tweaked in some ways. And so to achieve the goal that I think we would naturally have of maximum transparency, I think the end result is we probably would need a legislative fix. And so my understanding, though, is that the legislature may already be looking at that. And so we are ready to engage with them to the extent that comes to fruition. If they choose not to move it themselves and we engage with them in that posture, then I think a question for the commission, and it could be as early as April, is whether or not we want to affirmatively start trying to get a bill this session, or whether it's something we want to wait till next year to take up. But that's kind of the state of play today, is it was on our radar already. We were looking at it. We think there could be improvements in the statute. Sounds like they may already be doing that, so we're just waiting to see whether they actually do it.
Thank you. It's mostly for the public's benefit, but I appreciate that we're responsive to when we find out issues are happening. Based on today's earlier conversation, I would be curious about how those are audited. You know, when we talk, how we check on those reports, and if the only way they are pulled for an audit is if a particular, so the auditing of those reports could be part of that conversation as well.
I suspect it may be.
Thank you.
Thank you, Commissioner Baker. All right. So anything else for item 4 then?
No, I guess during public comment, there was a particular mention of a case that they're looking at. I'm looking at our enforcement chairs in the audience, in the chamber. So the individual is going to, the complainant is going to get a call potentially from someone from enforcement. We don't typically hear again at the commission what the status is unless it comes up on the agenda. Just want to make that clear.
Not
Yeah.
at this stage.
Okay, thank you.
All right. So we have nothing further. I will move to adjourn. Do I have a second?
Second.
All right, Ms. Linker.
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, thank you, everyone. See you in a couple weeks.